Hey, hello everyone. Welcome to the Patent Basics and VLA Pro Bono Patent Program webinar. I'm Melissa from the Business Insight Center at the Central Library of Rochester, Monroe County. Thank you so much for joining us today. Please remember to mute your microphones and enter any questions into the chat. We'll answer questions at the end of the presentation. This presentation is being recorded and will be uploaded to YouTube. If you have registered for the event, you will also receive an email with the presentation slides. Just a reminder that all services of the Business Insight Center and Carlson Center for Intellectual Property are free and available by appointment. And I would like to now introduce you to Emily Lehman, Director of Legal Services at the Volunteer Lawyers for the Arts.
Okay, thank you so much. So welcome everyone to this informational programming today. I just want to remind you that this is for informational purposes only. It's not legal advice. If you do need legal advice, you'll see in the program instructions on how to come to VLA to get that information. So to get started, why don't I tell you something about Volunteer Lawyers for the Arts? We are a legal services provider, which was founded in 1969 with a mission to provide pro bono, which means free arts-related legal representation and educational services such as this to low-income artists and also to arts-related nonprofit organizations. You can find us at vlany.org and on Twitter, Facebook, and Instagram as well if you're looking for more information. Today, we're here to talk about what is a patent, how to get a patent, and how VLA helps you to make your way down that road. So patents are a type of intellectual property. There are three types of intellectual property: copyright, trademark, and patent, which are all very different. And we are only today talking about patents. So patent is a right that protects someone's intellectual property, their mental work in creating something and in creating an invention. It prevents others from using that information, from making, selling, or otherwise using their invention without a license, without their permission. It only lasts for 20 years. So if you do get a patent, after 20 years, it expires, and then anyone can make that invention. And that's why you hear about things that, like medicine that's under patent, and then after 20 years, suddenly you have all the generics that are available. It only, excuse me, protects your property in the United States, or actually, US patent only protects your property in the United States. If you need to have a patent or want to have a patent in another country or worldwide, you would have to get patents in each of those other countries. This is important because people think that when they get a patent, then they have the rights around the world, but that's actually not the case. Now, the idea behind a patent is that it allows you to market your property. Let's say you've invented something mechanical that turns on lights. It has to, the patent itself will allow you to protect your rights against others. If someone else invents something that's too similar to yours, they won't be able to get a patent. Or if they use and invent or sell your invention, you can prevent them from doing that. If you're looking for investors, you can use a patent as something to lure investors into investing into your property, into your invention, and in order to sell it. You can find a manufacturer who will help you manufacture the invention and get it into the marketplace. And then, you can also sell your patent if you wanted to, or license it to a manufacturer or to someone else so that they can make money, but then they pay you for it as well. Now, there are three different types of patents. Utility patents are the most common. They are a patent that protects the mechanical method of making the item. So they're very, very technical. And if you have an improvement on a patent that you have already, there's another utility patent there to protect the improvements. A design patent is to protect design and the way something looks. So if it's a piece of clothing or a piece of fabric that might have a certain design, you can get a patent for that, but it's only for that how it looks and not for how it's used. And then something that we don't see at Volunteer Lawyers for the Arts, but something that's available are plant patents, which protect new ways of producing types of plants, which is kind of interesting. Now, besides those three types of patents, there are also two distinctions in the process. There's a provisional patent and a non-provisional patent. The provisional patent is just for 1 year. You don't have to make any specific claims about the item, and it's only allowed for utility patents, not for design patents, but it has to be very detailed in terms of what kind of disclosures that you have and how it is applied for. But it is a simpler process and it can be done just for that 1 year while you are developing a much more complicated non-provisional application. The non-provisional applications have to have at least one claim, meaning there are what you're claiming that your item can do, and your disclosures have to meet the standards of the statute, which says, as I have it here, that it must be a written description of the invention and of the manner and process of making and using it in such concise and exact terms as to enable any person skilled in the art, so not just any old person, but someone who's skilled in the art to which it pertains or with which it's most nearly connected, to make and use the same, and shall set forth the best mode contemplated by the inventor or joint inventor of carrying it out. So all of that language basically means the description has to be sufficient that someone can actually make the thing. And then the application is submitted, and if it passes the application and the examination of patent examiners at the US Patent and Trademark Office, then you might end up with a patent. So in the US, they have what's called the first to file system. So if you are filing for a patent, you have to be the first one to apply for that thing. If someone else has filed to patent the same invention, they will get the invention first. So what's really important is that, number one, you not disclose your invention to someone else because they might go ahead and file it ahead of you. But in the US, this is important. If you've disclosed it, for example, if you've gone to an inventors group and you know given them all of the details about your patent application, then you have 1 year. They will ask, has it been disclosed? And you have to declare whether it's been disclosed. And then you have a year to apply for the patent. If you've disclosed it more than 1 year in advance, you will not get your patent. Now, in the international realm, outside of the US, if you're looking to get a patent, you can't disclose at all. So before there's any public disclosure, you have to file your application. Now, there are fees for doing this. The USPTO has fees listed on their website. It changes, so I'm not going to tell you here what the fees are, but you can go to this website at the uspto.gov and click through to find where they disclose their fees. They are not small. It's rather expensive to get a patent, in the thousands of dollars. But there are also different fees for provisional patents, for non-provisional patents, for utility, for design. And so, and at each step along the way, you will see that there are fees. Now, one of the reasons to use the patent pro bono program is that you're not paying lawyers' fees, which is an additional fee. Then we'll talk more about that. Now, utility patent claims are the description of what you, the inventor, believe you have invented. You have to be very distinct in the claim about what your invention is. You have to conform it to the specifications that the USPTO has on their website and use very specific language about it. So you can't just write that, I've invented this thing that turns on lights, and not explain what it is and how it does it. That said, you don't want it to be so specific that you're really limited in what you can make. Because the idea is that you want to market and sell this item and you want it to be a marketable thing. And if it's too narrow, you're not going to find investors who are willing to invest in it because it might not really have a broad use. But if you are so general about it and you say, oh, I invented a thing that turns on lights, that's not patentable. It's too generic and too general. So you have to sort of thread that needle in your claims. So I mentioned a second ago, patent examiners. They are experts who work for the patent office and they read your application. They are very experienced and have to be able to understand what you described. They determine whether your application fits the requirements of the USPTO in providing a patent. They determine what's called the scope of the claim. So maybe your claim, the scope is, I invented a thing that turns on lights, but it's limited to, only a certain type of light. Maybe it only turns on, incandescent lights. Nobody's using incandescent lights anymore. In fact, they're being phased out. So that might not be very useful. So you're going to look at the scope of the claims and determine whether it's proper. They search through the entire universe of existing patents to make sure that this hasn't already been invented. They determine if, in that way, your invention is patentable. If someone else has already invented it, then you don't get a patent too, unfortunately. Now, they will write what their determination is, and what you get back from that is called an office action. It will tell you what they think about the patentability. Often office actions will recommend corrections, things that need to be done in order to make something patentable if it isn't right now, so that you then have to respond to that in a timely manner within 3 months to continue with the process. Now, the patent examiner does have to tell you why. If they just reject the application, they are going to give an explanation for that. So again, is it novel is one of the categories. Before you file your application, you have to do what's called the prior art search. That's something they will also do, but prior art is everything that's already been patented. So you also have to do a search to determine if there is anything else out there that your application might be too close to. So we have the statute here that describes what that looks like. Also, and this sounds a little counterintuitive, but they will say, well, let's say there's something out there that already does this. So, we all know about the clapper that turns lights on and off. If your change is so obvious that any ordinary person who might have some skill would be able to come up with this invention, then that's also not patentable. The language is, if the invention as a whole would have been obvious before the filing date of the claimed invention to a person having ordinary skill in the art. So, it can't be something that's just so glaringly obvious that anybody could have come up with it. There has to be some level of creativity and expertise that you've put into it that adds to the universe of things out there. Now, as I mentioned, you apply, you send in your application. There is an examiner who's examining your application. If they send you an office action, you will then have to go through the process of amending. You can amend it, you can rework it, send in your new application. There will be a second examination. They may at that time deny it. You do have the possibility to appeal. Later on at the end of the class, I will be explaining the appeals process. Now, after the patent is granted, let's say, you have protection. You have that 20 years that I talked about. There are fees, of course, because they will find a way to charge you fees at the 3.5-year mark, the 7.5-year mark, and 11.5-year mark to maintain your patent. Of course, you will be very interested in maintaining your patent if you've gone through all of this cost and time and energy to get one. So you want to make sure that you don't miss those deadlines. Um, there's also the possibility of correcting something in your application. Then you would submit a certificate of correction. They will reissue the patent, and then it might be a broadened. You might want to broaden your scope or something like that, so you can correct things if there are issues. Now, let's talk about the pro bono program, which is just as interesting, if not more interesting or more important than all of that. So the Patent Office has instituted this pro bono program that assists low-income or under-resourced inventors and small businesses across the country ever since 2015. So we're into 9 years now. The idea is to help people who have great ideas and great inventions get those patents who might not be able to afford it otherwise. So it's really, it's a challenge because it becomes, a matter of only people with resources can do this, except there's nothing that limits every person from having ideas and inventing great things. So they want to make that option available to everybody. And then there are programs around the country that provide the attorneys. So there are pro bono attorneys all over the country who are patent attorneys who are very interested in helping these inventors and will waive their fees in order to participate in the program. And this is the map from the current USPTO website. It shows in sort of color blocks where the programs are. In New York State, Volunteer Lawyers for the Arts is the administrator of the program, and we provide coverage in New York, New Jersey, and Connecticut. They call it the New York State Tri-State Region Program. We are Volunteer Lawyers for the Arts, even though inventors don't have to be artists, and their invention doesn't have to be arts related. It is still part of under our umbrella in our region. But if you live in any other region in the country, there will be a program to help you in any of those other states as well. Now, I sort of addressed this already. We want to help inventors reach their dreams. We want to help you get to the point of getting that patent in hand. Attorneys are very experienced in doing this work. They do it every day, the patent attorneys who work with us. And, you can do it on your own as what they say pro se without an attorney, but it's quite complicated and it's very helpful to have an expert on your side. There's a lot of procedures and a lot of rules. And, it's not necessarily something that's intuitive to go through that process. So it's helpful to have a pro bono attorney working with you. Now, one of the things that the attorneys will do, as well as helping file the paperwork and do the prior art search, possibly, not always, but sometimes, is that they will give legal advice about how to make your application most likely to succeed. They know what the patent examiners are looking for, and it's very important that if you're placed with a volunteer attorney, that you work with them, collaborate with them, and accept their advice. We do have clients who are very determined that their invention is exactly how they want it to be, but the attorneys know that the way that the application is worded will not necessarily pass the test. So it has to be worded in a very specific way so that the examiners will accept the application. Volunteer attorneys do this work out of, first of all, their desire to help people, but also you never know, a client may end up becoming wildly successful and then later can hire them in the future. And it's always good to have a relationship with people who, might be helpful to you. So having those relationships with the attorneys is very helpful. Now, it's sort of a two-way street. In order to get into the program, there is an application process. And so our process at VLA in New York is that there's an intake form on our website. The applicant has to fill out the intake form. It's just basic information about, name, address, all of that sort of basic information, contact information, a description, generally in the intake of what you are looking for a patent, to do a patent application. And then we have a back and forth process where we have to see that the person is financially qualified, meaning, we need to see tax returns to see that they're low income. We also have a questionnaire, a form called the patent questionnaire, which asks for more specific details about the application. It's all confidential. It's very important. People get nervous. It's not a public disclosure, so it doesn't trigger that disclosure issue that we talked about earlier. But it has to be specific. It has to include drawings. It has to include the kind of detail that you would put in the patent application. And then, once we have all of that, we go through an additional process on another slide to get to the process of placing you with a patent attorney. The volunteer attorneys are only specifically volunteering to help with what's called patent prosecution. That is filing that application for the patent. They may or may not agree to go through the office action process as well. I prefer that they do. I want them to see it through until the patent is issued, but not all of them are doing that. Some of them will only be volunteering for patent prosecution. Then if you get an office action, you come back and let us know, and we'll find a different attorney for the office actions. But we'll talk a little bit more about that. So let's talk about the patent questionnaire, though, specifically. Very important, has this invention been disclosed or published? We want to hear that the answer is no. We want you to have protected your idea, protected your invention by not disclosing it to multiple people, not putting it up on a website and saying, what do you think of this? Because that will interfere with your ability to get the patent. It means you just have 1 year since that disclosure. So you want to protect that. If there are co-inventors, if you're working on it with someone else, they also have to qualify to come through the program. So we need to know who those people are. Do you have other pending actions with the USPTO? We want to know, all of those things impact the time. Have you done a prior art search? We need to see a description. It's interesting to know what you think the market need is for this invention. Also then drawings and photos, the design detail, all of that. That's what's in the patent questionnaire. So we at VLA are attorneys, but we're not patent attorneys. So we don't make any determination about the application, whether it's sufficient or not, we don't know. But we send this information to patent attorneys to review, and they will look for deadlines. They will look to see if prior art search has been done. They will have more questions about the application. And in that case, we'll come back to you and say, these are the questions that the attorneys have asked. Can we have more information? Can you be more specific in your application? This kind of thing. And then we get it to the point where this is something that really looks like it can be patented. At that point, we will do an in-house consultation. What that means is that we only do these consultations on Zoom now. We don't do them in person, which is much easier, especially for people who don't live in New York City specifically, because that's where we're located. The attorney will go over the application with you. They'll have specific questions and have a conversation. And then this is really so that we can create what we call our case file and put this matter onto our case list, which is the list where the volunteer attorneys go to see if there's a matter that they want to take on. They can, if they have free time, if, they're in between paying clients, they might go to the case list and say, okay, I have time for this. I'm going to take this case. Then we send them the case file to review. If they're interested, they will then ask for the client. And at that point, the client will be introduced to that attorney and become the client of that attorney. They will have their own engagement letter with that attorney, and that is their attorney. Now, we don't guarantee how long it takes for placement with an attorney. In fact, we can't even guarantee a volunteer attorney will take a case. We are very highly successful in getting people placed, but we rely on the availability of the volunteers. We don't assign cases to them. So, because, we never know if an attorney is available, has time, or interest in that particular matter. So we can't do that. We cannot guarantee that a case will be placed, but it is very likely, and we are very generally very successful about doing that. But one of the issues there is that if you're under the gun time-wise and you have to file before a certain deadline, it can get very tight. And so what that means is it's very important to come to us immediately if there's been any disclosure. Come to us immediately if you have an office action and there's a 3-month deadline to file. I think after that you have another 3 months, but you have to pay a fee or a fine or something. And so we want to make sure that there's sufficient time and no time pressure. And so that means that you, the inventor, has to make sure that you don't sit on something and then come to us much later and then be concerned about the time. So as I mentioned, I've already described this matching process. Once an attorney is found, there will be an engagement letter with that attorney. That attorney will not charge any fees. That's the idea behind the pro bono program, is that they will not be charging fees for any of their services. That said, the USPTO does charge fees. There are lots of different fees for different things. As I said, you can find those on the USPTO website. If there are issues with reaching the attorney or communication, we're always around. We, like to help facilitate that kind of thing, but we at VLA, again, are not able to, we don't represent the client at that point. The lawyer that they've been placed with is their attorney. So it's really important to be very clear and communicative with your attorneys, because they also need to be able to reach the client and need to be able to communicate with you. So we want that to happen. I do think I have a couple of questions. I'm going to wait till the end to answer now. As I said, the attorneys definitely take on the case for patent prosecution. It can take us, a long time or a short time, depending on how prepared the client is. They don't always immediately take on the office action, so you might have to come back to VLA. But if you're lucky, the attorney you've been placed with will take on any office actions that come in. But again, you have to be very proactive if you get an office action in contacting VLA immediately and letting us know, or the attorney that you've been working with immediately, and find out from them whether or not they're going to go forward with it, or if you have to come to VLA. The attorney has the obligation to be clear about when their representation ends, but again, the client should also be very forthcoming and communicative, and if you have any questions, you have to talk to your attorney. Now, let's say you've received a final rejection. That means that the USPTO has said, this is no longer being considered. Your patent has been rejected. You do have, I should say, this language is sort of geared towards the attorneys, just to be clear. This is from a presentation for attorneys. The volunteer attorney has to let the inventor know if they're the ones getting the notifications. Sometimes the client is getting the notifications, sometimes it's the attorney. And so the client has to be informed and the attorney has to be informed that there is a final rejection. Now, it's also very helpful, and we need to know at VLA, what was the result? We really want to know when a patent has been issued. If you're issued a patent, let VLA know, because the USPTO asks us, you'd think they'd know because they issued a patent, but they ask us every quarter about sort of what's the results of all of this work. Have any patents been issued? So if you can keep us in the loop, that's really helpful too. But if there's been a final rejection, that's also very helpful. Now, once that happens, the volunteer attorney will withdraw. They are no longer part of this process. But there is another program, just so you know, there's another program called the PTAB Pro Bono Program, which is the appeals board, the Patent and Trademark Appeals Board. So this appeals board has to be informed. You have to request assistance within a month from getting your rejection, and you must still financially qualify. So you would still have to go through the financial qualification process. It is separate from the VLA Pro Bono program. But this is something that is really useful and helpful to know about. And if you have gotten to the point where your patent has been rejected, you will very likely want to appeal because you put in a lot of time and money and energy into getting to that point anyway. So if you are part of the patent pro bono program to begin with, you would let them know that as well, because then they will pay attention and expedite your appeal process as well, which is very helpful. Now, important details. You can file an appeal after you've had 2 non-final rejections or a final rejection. In both of those scenarios, you have 6 months to file notice of appeal, but as I mentioned earlier, you have to request assistance from the pro bono program within a month. So even though you have 6 months to file that appeal, you need to get into that program, bono program immediately. You have to, once you're in the pro bono program, the appeal brief itself, which was be filed with the USPTO, has to identify the inventor, the person who has an interest in appealing. If there are any other related actions going on, excuse me, a summary of the matter, arguments about why the examiner was in error, and that's one of the occasions where you'll be very helpful to have that pro bono attorney as well, and then listing the claims that are being appealed. So this is very important because, again, just like the original process, they are very strict about following the right procedure and doing it all the correct way. And this is a successful process. People do succeed in their appeals, and it is possible to get that patent in the end. Now, I have a couple of questions, and I think I addressed this, but I'll answer it again. Do you have to be in the arts to qualify for the patent program? No, you don't. Inventors are not necessarily artists. I mean, I think there's artistic effort that goes into a patent as well, but you do not have to be an artist. What if you have an applicant that doesn't know how to use Zoom or is not computer literate? We can do these conferences by phone as well. So they don't need to be Zoom literate, but it's definitely helpful. I think we all have learned over the last 4 years how useful being able to communicate and see each other as well can be. How many times are you able to appeal a rejection? You get one appeal for a specific claim. So you can't just keep coming back and appealing and appealing and appealing. So there may be, a patent attorney would be the better person to ask that question. There may be distinctions about that. There might be a specific element of a rejection that you're appealing, and then you can appeal a different element, but I don't want to speak to that because, again, I'm not a patent attorney. So that's where we are. So I think questions have been answered. That's what I have for you today. I hope it's been helpful. And I hope to see you all coming to us with your inventions and getting you patents at some point.
Okay, that is the end of our program. I'd like to thank Amy for speaking with us today. A recording of this presentation will be posted on YouTube. We will email all registered participants with a copy of the presentation slides as well as a link. Thank you.
Thank you. Bye.